underlying theory, certainly, because one of the other interesting things about all of this, and Sheriff Christopher talked a little bit about, the fortuitous or maybe divine intervention of me meeting him and coming together and talking about this. I actually, being in Michigan, when I was doing the research for the lawsuits that we filed in Wayne County, which is the biggest county where Detroit is, Allor versus the Board of Wayne County Auditors is an 1888 Supreme Court case out of Michigan, written by Justice Thomas Cooley, who was one of our premier justices on the Michigan Supreme Court in history, and who also is the author of the 2-volume treatise Constitutional Limitations, which is the premier manifesto, if you will, on the right of the states to govern themselves, and primarily the right of local governments to govern themselves. Constitutional Limitations is the name of the treatise, and it's still in circulation. Justice Cooley was probably parallel to Justice Joseph Story in terms of his knowledge and understanding and his writings on the Constitution from a state perspective, as was Justice Story from the U.S. constitutional perspective. But the Allor case stood for the proposition that, which I spoke of earlier, that the common law powers retained by the sheriff when his office was named as a constitutional office, and it is a constitutional office in Michigan, as well as many other states, the majority of states across the country. What that means is, as I said earlier, it gets in the constitutional imperative. So the theory is that if the common law powers of the sheriff were, and they certainly were, that the sheriff had the power to arrest, conserve the peace, to call out the citizens of his county on his behalf to enforce the law, if that was a right and a duty, actually, that the sheriff had when the sheriff was named as a constitutional officer, then that right is retained until it's abrogated by constitutional amendment only. So the only way you can remove that power is through the people amending the Constitution. And the more important thing of that is three main things of that is, number one, judges certainly cannot do it, at least the lower court judges. And I would submit that the Supreme Court judges couldn't do it because, like I said, it has to be a constitutional amendment to remove that power. Legislatures certainly cannot do it. And the other side, the flip side, the end result of attempting to do something like that is it affects a disenfranchisement of the people. The citizens vote who they choose to enforce the law in their county on their behalf by popular election. And the moment that you allow a different authority to come in and try to infringe upon the sheriff's powers of arrest or any other common law power that he has, whether it be directly by the legislative action that the Delaware General Assembly has attempted to take, or indirectly by budget cuts. Sheriff Christopher, mentioned that they reduced the salary of the sheriff to a minuscule amount, so to basically prevent him from being able to assert his authority and power.
Yeah.
Those are unconstitutional measures that are taken by individuals who have basically running roughshod over the constitutional rights of the citizens. And so this theory of law, this common law rule that came out of the Allor case, it was also enunciated by a case out of Wisconsin about the same time by a contemporary Supreme Court, is the rule of law in our United States of America. And it's a rule of law that has been cited in many other states for the propositions that I have, that I espouse, and that are the controlling rules of law. And in fact, there's a Delaware Supreme Court case that cites this very principle, and it actually cites the Allor case out of Michigan, but that case in particular didn't rule upon the particular rule. So in other words, it was a Supreme Court case out of Delaware, but it never extended the rule. It basically reserved it for another time, and that was the applicable rule in Delaware. And I would submit that, with all modesty, that this case here that Sheriff Christopher is fighting is the case that, has the potential to allow a brave and courageous Supreme Court to do the right thing and to basically espouse that rule once and for all, as it should be.
Yeah.
It is the rule of law.
So are you talking about the potential to go all the way to the United States Supreme Court, to the top 9?
when I say that, of course, who knows what the state's going to do?
Yeah.
The state of Delaware
To interfere.
And, when we look at the formation of the Constitution, a person has to go into history and understand why, and they cited the British common law, and which is a lot of practice, if you will, by the British system, and the colonials adopted quite a bit of it, and it flowed into our system of laws, and of course we changed things with more specificity. Anyway, you are in luck if diffident of the Supreme Court, because the Chief Justice Kennedy, Robert Kennedy, he's a history buff. And some of these other people may not understand history so well and how it actually does influence court decisions. But you have kind of a leg up there with Kennedy. Scalia is into history too.
Yep.
He cited some stuff way back, like
way.
Other justices have done the same thing. But I do want to ask a fundamental question about the Delaware Constitution. If the Delaware Constitution names the sheriff's office, and of course you'd have to go back to the intent when they wrote the Delaware Constitution, because the intent was what it was in practice, what was going on, and what they meant based on history. So I don't know if you want to comment about if it is in the Constitution or not of Delaware.
Yeah, I mean, Sheriff Christopher mentioned it, and it is, and what I was going to say earlier is that Sheriff Christopher hit up on a very, very important point, because Michigan's Constitution only says that the sheriff shall be the elected law enforcement officer of the county, or something to that effect. The Delaware Constitution actually contains explicit language in the article itself that says that the sheriff shall serve as the conservator of the peace. And so in terms of what that, I mean, you cannot be any more clear and direct in interpreting it from a plain language perspective, as you mentioned, the conservative Supreme Court justices on the United States Supreme Court would do, than to conclude anything but that the sheriff has arrest powers in his county on behalf of the people. To get the case, however, into the U.S. Supreme Court, it would have to come from a sort of a different perspective, and I think that would be where the disenfranchisement of the people of the county would have to be, they would have to assert standing from a different perspective to get a case like that before the U.S. Supreme Court. When I mentioned the Supreme Court, it's got to be the Supreme Court of the state, at least at this initial stage. I mean, we do have the United States Constitution amendment, one of the Bill of Rights articles mentions that the Republican form of government is guaranteed by the Constitution of the United States. So to the extent that that would affect the disenfranchisement of the people's right to vote who shall enforce the law in the county on their behalf, then that's one possible challenge. But I think the more important point here is, in terms of the Delaware Constitution, you've got a case that has constitutional language that could not be clearer. And a lot of the state constitutional provisions that name the sheriff as a constitutional officer, even though we all understand what that means in terms of the rule of law, which I mentioned earlier, Delaware's Constitution actually has the very provision that Sheriff Christopher is asserting is his right, which is to conserve the peace. And there is, again, like he said, no question that that means the power of arrest. I mean, it's almost, for people for common sense folks like us who look at that and say conservator of the peace, it doesn't take much of an extrapolation to conclude that he has the authority and the responsibility, frankly, to enforce the law, which means to arrest those who would seek to break it.
Exactly.
So it's in a good posture in that regard. Now, unfortunately, it depends upon the makeup of the particular Supreme Court of the particular state. Pennsylvania's Supreme Court has had a case pending for, I think, over a year now, since October of 2011, that is attempting to reinstate, if you will, the sheriff's arrest powers in the state of Pennsylvania. And that case decision hasn't come out yet, to my knowledge. But from what I understand in talking with the Sheriff's Association of Pennsylvania and the president of that organization, they've got a pretty good Supreme Court in Pennsylvania, and they think it's going to be done properly. Pennsylvania's got a good case that came out in 1997 Leak versus Commonwealth of Pennsylvania, which really detailed the history, cited the rule of law that I've already talked about, and basically concluded that the sheriff does have arrest powers by virtue of his place in the Constitution of that state. And the United States Supreme Court in 1885 issued an opinion in South versus State of Maryland, in which they detail some of the history and the importance of the constitutional powers of the sheriff being that of the powers of arrest, and those that were the powers of common law prior to his naming in the respective states' constitutions. I mean, you've got, I can tell, and I know Sheriff Christopher knows this, we've got the law on our side, and again, we're dealing with, for lack of a better term, ignorance all the way up and down the chain.
Yep.
And to some extent, there is, a collective or maybe discombobulated conspiracy to remove what is essentially the powers of the people to choose who is going to enforce the law in the county on their behalf. And so that's what we're fighting. Unfortunately, it shouldn't be an uphill battle.
It shouldn't be.
It's not an uphill battle in my mind because we have the law on our side, but
Yep.
It's an uphill battle because our society has bred ignorance of the law.
Yep.
Wow. So I'm just kind of summarizing real quickly. So you have, and of course, you studied the history. Both of you have studied the history. You have a sheriff that is fighting. He has his own legal team in Delaware. He's got U.S. Special Counsel. You have got the Delaware Constitution going back, the history of Delaware going back. You have got other case law that's supporting this position. So it looks like you're in a really good position to keep moving on. I mean, it doesn't matter what the legislature...
Probably parallel to Justice Joseph Story in terms of his knowledge and understanding and his writings on the Constitution from a state perspective, as was Justice Story from the U.S. constitutional perspective. But the Allor case stood for the proposition written by Justice Thomas Cooley, who was one of our premier justices on the Michigan Supreme Court in history, and who also is the author of the 2-volume treatise Constitutional Limitations, which is the premier underlying theory, certainly, because one of the other interesting things about all of this, and Sheriff Christopher talked a little bit about, the fortuitous or maybe divine intervention of me meeting him and coming together and talking about this. I actually, being in Michigan, when I was doing the research for the lawsuits that we filed in Wayne County, which is the biggest county where Detroit is, Allor versus the Board of Wayne County Auditors is an 1888 Supreme Court case out of Michigan, manifesto, if you will, on the right of the states to govern themselves, and primarily the right of local governments to govern themselves. Constitutional Limitations is the name of the treatise, and it's still in circulation. Justice Cooley was